morning. My name is Elisa Scally, and I am a partner with Gowling WLG in the Employment, Labor and Equities Group in the Ottawa office. I'd like to welcome you today to the second webinar of a 6-part webinar series that's being presented by our Employment, Labor and Equities Group. If you missed our first webinar on AOD compliance, this webinar is posted online, and we will be including the link to the post in the chat if you'd like to access this session at a later date. Today's session is focusing on a topic that is on the minds of many employers these days, and that's mandatory vaccinations. Can you require your employees to be vaccinated? What are the risks if your employees are not vaccinated? Can you require proof of vaccination? Our speakers today will be answering all of those questions for you and much more. If you do have any additional questions for the speakers, please add them to the Q&A, and we will do our best to address your questions during the session today. There will also be a PowerPoint presentation. That PowerPoint presentation will be sent to you by email following the session. I'd like to introduce our speakers today: Chris Andre, Tushar Anandsagar, and Cedric Marsan-Lafond. Chris Andre is a partner in our Waterloo Region office. He is a trusted advisor to employers, and he has been ranked by the Legal Expert Directory, Legal 500, and Best Lawyers in Canada for his expertise in employment law. Chris grew up in Saskatchewan and is a diehard Saskatchewan Roughriders fan. He's anxiously waiting for COVID to end so that the season can begin. But in the meantime, he will be cheering on the Leafs, and I think there is a big game tonight. Not a big hockey fan, but I think there is a game tonight against the Montreal Canadiens. Tushar is an associate also working out of our Waterloo Region office. His practice focuses primarily on management side, employment, labor, human rights, and privacy law. He advises employers on everything employment, from onboarding to statutory compliance, Ottawa workers' compensation, human rights, and so on. Tushar says he loves being a lawyer, but if he had to pick a second career, he would love to drive a race car, assuming someone would sponsor him. And who knows, maybe one day you'll be driving a race car sponsored by Gowlings. Stranger things could happen, like being in the middle of a global pandemic and talking about mandatory vaccinations in the workplace. Cedric is an associate working out of our Montreal office. He also has a practice that focuses on employment. He advises Quebec employers on labor standards, dismissals, collective dismissals, and disciplinary measures. Cedric lives in Montreal, but he says he knows more about the streets of Boston and New York from his days as a tour guide in the US. So if you have any questions about vaccinations or need to know about the sites in New York or Boston, you can follow up with Cedric after the session. So why don't we get started, and I'd like to hand it over to Chris.
Thanks, Lisa. It's great to be with everyone, especially across the country. We've been having lots of questions about these topics across the country, and we're happy to help our employers as we go along. These are difficult questions, raising lots of issues, and so I'm going to turn it over to Tushar to sort of run through what we're going to do for the day, and then we'll get going.
Thank you so much, Chris. Thanks everyone for joining us this morning, bright and early. I don't know what time it is where you are, but I know it's really early on the West Coast, so thank you for thank you for tuning in. I'd like to start off just by framing the discussion. We're going to be talking about workplace vaccination policies, but as the title suggests, there are a couple of other items that we'll be covering. And one piece that I think is going to come up as part of the Quebec discussion is the rapid antigen screening component, which is going to be very, very significant. So please stay tuned, and a quick rundown. We've got a lot of ground to cover. We'll start off by talking about sources of authority for a mandatory vaccination policy. What does the law say now? What does the law say in your jurisdiction? Number two, we'll talk about risks of implementing a mandatory vaccination policy. Again, keeping in mind what the statutes say, what the common law says. Third, we'll talk about the converse. We'll flip the script. We'll say, what is the risk of no mandatory vaccination policy? Is there a risk under occupational health and safety law? And in the event that there is no mandatory vaccination policy, what could practically happen to your business? Fourth, we'll talk about the middle ground between no policy and forcing the issue, vaccination incentives. So you'll definitely want to stay tuned for that. And item number 5 on the list, which we've put at the end because it's probably the most interesting one out of all of this, and probably some material that you haven't heard before. Practical issues that could happen in the future based on what we see. We're privileged to have a bit of a bird's eye view with respect to what's happening in a variety of workplaces. And so definitely stay tuned for that. And finally, I'll earmark this as number 6. We will do our absolute level best to cover all of this and get to your questions so that we can talk about some Q&A as item number 6. If I could have you flip to the next slide, please. So, as promised, we are starting off with sources of authority for a vaccination policy. Well, our starting position for most of Canada is fairly straightforward. At present, we don't really have legislation that requires an employer to vaccinate employees, at least not yet, not yet. If we look at the situation in other jurisdictions, and we're looking squarely at our neighbors to the south here, we have much more severe consequences in the context of the COVID-19 pandemic. And so we see that the legislative framework has actually been approached in a different fashion. We have open statements about what is and what isn't permissible under law, and specifically employment and human rights law. We're also dealing with different realities. They had a significantly higher death toll and much more severe consequences, I would say. So in terms of legislation, the first kind of bolded point over here, we don't have new legislation. We don't see this in the pipeline for most of the provinces that we are in. But I will say this, and Cedric will most definitely cover this off. We are already seeing movement here in Quebec, and we're going to be happy to walk you through some of those changes. So looking at this generally from the standpoint of most of Canada, leaving aside Quebec for the time being, the primary motivation for this analysis and for this discussion is occupational health and safety. We want to keep our workplace safe. We know the consequences of the COVID-19 pandemic can affect not only individuals at your workplace, but the general community, their families, their children, their parents. The consequences are substantial, and we are obligated as employers, plural, to take in some form or another under legislation in your jurisdiction every precaution reasonable in the circumstances to keep the workplace safe. And so that is quite broad, every precaution reasonable in the circumstances. The reason the legislature has put that provision into occupational health and safety legislation is to capture future issues. That is broad, forward-facing language that is intended to capture future issues that are not yet known. In Ontario, the OHSA was implemented in its current form in 1990. No SARS, no MERS, no COVID. But this particular provision allows for an expansive approach to the legislation. Okay, so maybe we can justify it under a vaccination policy under the occupational health and safety side. But what about precedents from other sectors? What can we learn from sectors such as schools and daycares? These are sectors in which we are seeing these changes happening in real time and established rules, procedures, and protocols that have been in place for quite some time in advance. I'm going to read through a list of public sector school immunization requirements for the province of Ontario. And keep in mind that this is a partial list. I'm going to move through it fairly quickly. Diphtheria, tetanus, polio, measles, mumps, rubella, meningitis, whooping cough, chickenpox, etc. What are the requirements in order to send a child to a public school in this province? Parents must provide proof of the child's vaccination and immunization record to the local health unit. They need to keep the immunizations up to date. Children who do not get immunized are at an increased risk of disease, and they may be removed from their school during a disease outbreak. So this has already happened in the public school sector. That's dealing with students. What about employees specifically, employer-employee relationship? How does this affect employees? Well, let's look at the daycare sector. We see the list of mandatory immunizations for this particular sector as well as being quite lengthy and similar to the ones that we just read through for the school's children. Tetanus, diphtheria, pertussis, measles, mumps, rubella, varicella, hepatitis B. These are mandatory for purposes of outbreak containment in the daycare sector for employees. And so we already have a precedent set in Ontario, for instance, that requires mandatory vaccination in certain high-risk, quote-unquote, settings. That the precedent has already been set. And what is the primary justification for this? It ties back to that first bullet point there, occupational health and safety and the general health and safety of the populace. I'd like to transition over to my colleague Cedric, who's going to talk about, as promised, some of the new changes that are happening in Quebec. Cedric, it's quite a different outlook. Why don't you take it from here?
Thanks, Tushar. As you mentioned, it's quite different in Quebec, as we're the only province with civil-based law and not common law like in the other Canadian provinces. I just wanted to touch base to start with the Act respecting occupational health and safety, which will certainly be the basis of some employers to try to have vaccination policies. As Tushar mentioned, the employer has the obligation to protect the health and safety of its employees. The situation is a bit different in Quebec because we also have fundamental rights that apply to every individual. We have the Charter of Human Rights and Freedoms and the Civil Code of Quebec that provide rights that apply to every individual. This includes employees. Those two statutes, I just wanted to address three rights that are provided in them. The first one is in the Civil Code of Quebec, and it is the right of autodetermination of healthcare. This means that a person can decide which healthcare he or she receives. And this is important because this means that you cannot compel an employee to receive the vaccination. However, and we'll see it later in the presentation, you can require vaccination for a certain position, but you will not be able to compel an employee to receive the vaccine, which are two different things. The second right that I wanted to address is the right to integrity that is provided both in the Charter and in the Civil Code of Quebec. And this allows a person to preserve the integrity of his body. And vaccination, it could be argued that it is an intrusion to that integrity as you are injecting a foreign body in your body. The third right that I wanted to address is discrimination that is provided in the Charter of Human Rights and Freedom. So, and we'll also touch base on this issue later in the presentation, but everyone has the right to full and equal recognition of their rights without discrimination. And there's certainly prohibited grounds in discrimination in Quebec, including religion and disability. And this could impose the employer to have a reasonable accommodation policy to the point of undue hardship. The really interesting thing about Quebec and distinguishing it from the other provinces at the moment is Ministerial Order 2021-024 that was adopted in April. And basically, by that ministerial order, the government took action for workers of the healthcare sector, more specifically a high-risk sector. I'm talking about emergency units, intensive care units, and pneumology units, other units identified in the ministerial order. For those specific sector, the government now requires that these employees give a vaccination proof to their employer. If the employee does not accept to be vaccinated or to give vaccination proof to the employer, well, the second measure is for the employee to be tested 3 times a week to have COVID-19 testing and give the result of this testing back to the employer. If the employee refuses to undergo the testing or give the result, the third measure is to try to reassign the employee in other duties. And if the reassignment is not possible, or if the employee refuses to do so, well, the final measure that is provided by this ministerial order is to remove the employee from the workplace without pay. So this is a novelty in the COVID-19 situation. And as we'll see in the next slide, this is kind of useful to establish the applicable grounds in Quebec, because we do not have a lot of case law. From what is available right now, there's only one decision that is relevant for COVID-19, and is a precedent of 2008 in the long-term care facilities about an influenza outbreak. So basically the situation was the following. It was a CHSLD, so a long-term care facility with senior citizens, and there was an influenza outbreak as several beneficiaries of the facility contracted influenza. One of the employees has been in contact with those beneficiaries, and we do not know yet if the employee contracted the influenza. But the employer had a mandatory vaccination policy, and well, the policy provided that you could take the vaccine, or if you refuse to take the vaccine, well, you'll be removed from the workplace for 72 hours just to see if you develop the influenza, and you'll be sent home. And when you're being sent home, either you are benefiting from your banked days off, or if you do not have any bank days off, well, that you're being sent home without pay. And in this specific situation, well, the employee filed a grievance because she was sent home without pay. And the arbitrator ruled that it was not unreasonable to have this policy, as it was important to protect our senior citizen and was justified under the charter, and that the employee was informed prior to this situation. So this is kind of the precedent we have in Quebec, and I believe there's more in Ontario, and I'll pass it to Tushar and Chris.
Thank you so much, Cedric. 2008 was the year of the mandatory influenza vaccination policy. Apparently, in Ontario, and this is a summary of I guess the Ontario and other provinces outside of Quebec case law in a nutshell. In Ontario and other provinces, we have mixed results as well, Cedric. We have all of these cases are coming out of the healthcare context. We don't consider circumstances, generally speaking, that are outside of the healthcare or long-term care context. They're unionized workspaces, which doesn't really do much in terms of setting a precedent for non-unionized workspaces that are currently dealing with a pandemic. And they are congregate living environments. So a similar kind of a framework to that 2008 case. I'm going to move quickly through a couple of precedents that affect the common law jurisdictions. So 2008, as mentioned, we had a mandatory vaccination policy upheld in a North Bay hospital decision. In that particular case, the arbitrator actually considered circumstances where the Ministry of Health had actually made a recommendation to the North Bay General Hospital to implement the influenza policy in question to contain a pocket outbreak, a little outbreak by comparison to what it would have been major at the time, but little compared to what we're currently dealing with in real time. We'll fast forward a little bit to BC Health and what I will call the vaccinate or mask or VOM cases. In BC Health, and you know, this is probably the closest thing that we've had to what we're currently dealing with in real time. We had an arbitrator uphold a policy that actually required employees to either wear a mask or provide proof of vaccination against the seasonal flu. The policy itself had been implemented in response to low rates of immunization because there was some pushback from employees that were not too keen on being immunized through voluntary vaccination campaigns, on-site vaccination clinics, as we're seeing rolled out throughout the country during COVID-19. The vaccinate or mask policy actually, as it also stated, that an individual found to be non-compliant could be subject to remedial and or disciplinary action up to and including termination of employment, cancellation of their contract, or revocation of their employment privileges. So what was the outcome in that case? The arbitrator actually looked at the policy and determined that the policy was reasonable, having regard to the risks, the evidence, and the factors that were affecting the employment relationship, as well as the risks posed to the general public. So expert evidence, number one, weighed in favor of the fact that immunization of healthcare workers actually reduced the transmission of the flu to patients. Number two, the expert evidence, and we've seen a lot of that over the course of the past 15 months, indicated that masking had a patient safety purpose, quote unquote, and that the effect of masking sufficiently accommodated healthcare workers who were conscientiously objecting to vaccination. Number three, the vaccinate or mask policy was not discriminatory because it did not actually require immunization per se. The employees had an option to wear a mask instead of being vaccinated. It was the vaccinate or mask. And finally, the British Columbia Center for Disease Control, in that particular case, the BCDC, not to be confused with the place that Dr. Fauci works at, had endorsed the employer's policy in 2012. So we actually had a regulator come in and say, this is a reasonable policy. Not the same outlook in Ontario. We've had a little bit of a struggle over the course of the past 6 years in this particular space and dealing with the same issues. So in 2015, we had the Sioux Area Hospital case where the arbitrator also found that, the arbitrator conversely found that the mandatory vaccination policy, similar to what was introduced in British Columbia, was quote unquote unreasonable and an impingement of employees' rights under their collective agreement. The employees in that case, the grievers, refused to be vaccinated on conscientious grounds, and the arbitrator actually stated that the requirement to wear a mask as a fallback option had placed a significant demand on employees who exercised their right not to be vaccinated. They talked about stigma associated with masking. They talked about the effect that it might have on the workplace itself and possible intimidation affecting the employee-patient relationship and how things have changed. So in that case, again, 2015, the arbitrator says this is an unreasonable exercise of managerial discretion under the collective agreement. Similar outcome in 2018. More recently, we had an arbitrator weigh in again on a vaccinate or mask policy and weigh against the reasonableness of the policy. And I'll read a quote here. I promise it'll be short. The arbitrator characterized the issue in the following manner. The question is whether the evidence supports the conclusion that the use of surgical or procedural masks worn by unvaccinated healthcare workers for some or all of the flu season actually results in reduction of harm to patients. Does it prevent the transmission of illness? Does it save lives? If the VOM policy prevented patient illness and saved patient lives, its reasonableness would be difficult to challenge. And that quote actually suggests that the arbitrator landed on the opposite conclusion. How things have changed. I'll reiterate that once again. As was the case in the Sioux Area Hospital, the arbitrator says the evidence doesn't support that masking as a mandatory mandate as a fallback to vaccination is sufficient, adequate, and completely persuasive in favor of arresting or reducing risk during the context of a pandemic. So the arbitrator found that the masks were not an effective means of source control, and therefore they were unlikely to stop the transmission of the flu. And so let's look at this in terms of key takeaways. We believe that the St. Peter's, St. Mike's cases, particularly the ones in Ontario, if they were decided and evaluated in the context of the COVID-19 pandemic, and we have seen a recent case dealing with PCR testing called Crescent Care during the context of COVID-19, which has flipped the script and actually come down in the exact opposite place as a result of the risk factors being posed by the COVID-19 pandemic. That case deals with PCR testing. We believe these other cases that were decided in Ontario would line up with the BC decision in 2013, in that they would say that vaccination or masking would be a reasonable outcome and a reasonable policy for an employer to take given the risks that are posed by COVID-19. Another key piece to take away from this is that looking at that recent case, the Crescent Care decision that deals with PCR testing, this is a precedent that deals with COVID-19 and the risks we're facing here and today and now. The vaccinator mask cases may not be sufficiently relevant for COVID-19, which means that we're in a little bit of a precedent case law vacuum. And I do believe that this particular space, there's going to be a lot of litigation and a lot of action going on over the course of the next couple of years as we sift through what is reasonable and try to make sense of the past decades worth of conflicting decisions and mixed case law results. Chris, I'd like to transition to you. For most of the country, we've been getting these mixed signals regarding the authority to set up this kind of a policy. Perhaps you could walk us through some of the risks associated with pushing forward and establishing a mandatory vaccination policy per se.
Thanks, Tushar. It is a bit frustrating, I'm sure, for everyone to recognize that the law is well behind what's happening down on the ground. So what we want to talk about in this section is what are the risks of implementing a mandatory vaccination policy. We've certainly had discussions with lots of clients who are saying, we really think this is where we should go or we want to go. what's the consequence if we decide to go in that direction? And so the starting point for the analysis, as Cedric mentioned a few moments ago, is you are requiring someone to undergo a medical procedure. So in terms of if you think of the sort of impositions that we put on people during this pandemic, there is a spectrum. We've had temperature checks. There was lots of discussion around that. We've had masking. There has been obviously some government imposition there. Then we had some discussion around negative tests. I would suggest that requiring vaccination is at the furthest end of the spectrum in terms of what we are requiring employees to engage in. Consequently, like with many issues related to privacy and the security of the person, the closer you get to someone's body, or in this case, inside their body, you're going to face resistance. So I think the way that most employers need to recognize and address the issue is the ability to justify mandatory vaccinations will depend upon your workplace. It's going to vary from workplace to workplace. In our view, the more congregate the setting, the more likely the policy would be found to be reasonable. So to again use some of Cedric's examples and the Quebec government's examples, hospital environments, long-term care facilities, you're moving along the spectrum. Food processing, you're moving along the spectrum. Retail, where people are coming and going, not necessarily staying, but they are staying for a period of time. To the other end of the spectrum, where you have office workers and those workers that can, work from home. So tech workers who, some of the large companies, they may never require their employees to come back. So it's obviously difficult to justify a mandatory vaccination policy when few or no people are coming into the workplace. So it's going to depend upon what your industry is. And then the second thing that you need to recognize is very few workplaces are sort of monolith. They're going to have different operations or different components to the overall business operation. Blended, hybrid. So you're going to have a production area where people may not be able to socially distance, where they may be close to one another, where they may be exerting themselves and therefore breathing more heavily. Compare that to the administrative section of the business, where you're in potentially individual offices, or you're in individual workspaces that can be properly spaced. You can make social distancing allowances for people to get to and from washrooms, exits, entrances, etc. So as you are considering this in your workplace, you need to recognize that your workplace is where it fits on that sort of spectrum and the different elements of your workplace. If I can get you to switch the slide. So I'm going to focus in on some of the human rights risks, because this consistently comes up as sort of the quick reasons to resist the mandatory vaccination. So the first is, think of them as physical reasons to resist. One obvious one is you're allergic to the vaccine. That is not a high proportion of the population. There are certainly risks to some, but it is not a large section of the population. A second section of the population that may resist are women who are pregnant. The data just isn't sufficient to allow people or most people to feel comfortable, but that is developing. And so it is not a static situation where you can simply say, pregnant women cannot be vaccinated. We may get to the point where there is a sufficient amount of data to suggest that there is no risk to the fetus. So those are some of the obvious physical reasons to reject. A second basis for many people to reject are religious reasons. The first is sort of their faith would prevent them from doing it. Again, that is a very small section of the total population. There are some, and I'm not learned in this. I didn't do, a PhD level research, but I certainly did some background checking, and there are very few what you would consider to be large population, religious populations that are opposed to vaccination. So some of them that are officially opposed Dutch reform, any sort of faith healing denominations which believe that any physical problem can be resolved through prayer, but the largest religions that one would be familiar with have officially, as far as I can tell in my research, come out in favor of vaccination. The Christian religions, Judaism, Islam, Hindu, Buddhism, they're all in favor or not opposed. And so when you are examining this, you need to recognize that you're probably dealing with a fairly small section of the total population. One of the things that has come up is some Christian religions are opposed based upon how the vaccine was developed or how they believe the vaccine was developed. And again, I'm not learned on this. I'm not going to come to a final conclusion, but there is evidence that vaccines, not necessarily these vaccines, but vaccines in general, were developed through the use of aborted fetal cells. Consequently, there are some religious groups that are opposed to any vaccinations because of its origins. The information that I was able to find was that these the vaccines that are available in Canada were not developed using that technology and using those originating cells, and therefore the vaccines themselves are not the product of the use of aborted fetal cells. There is some evidence that some of the testing that was done to check the efficacy of the vaccines did use some of those technologies, but the vaccines themselves did not. And so, again, that is a fairly small section of the population. So again, you're going to have to consider the accommodation requirements as those issues arise. A third thing that I wanted to talk about is sort of strongly held views. So some people are very opposed to vaccinations in general. Some people believe, as you would have read in social media, some people believe that the vaccinations are being offered and implemented for nefarious purposes. And so one of the things that I wanted to address is the issue of creed, at least in the context of Ontario. The definition of creed in the Ontario Human Rights Code has been found to address, and this is the Ontario Human Rights Commission's view on it, that creed addresses ultimate questions of human existence, including ideas about life, purpose, death, and the existence or non-existence of a creator and or a higher or different order of existence. So the definition of creed does not or would not likely capture a relatively focused issue around being opposed to vaccinations. And so I would invite employers to be rigorous in their consideration of whether someone who has a strongly held view against vaccines has human rights protection, and therefore the employer is at risk of a human rights complaint. The next slide, please. When you're dealing with any human rights issue, of course, you have a duty to accommodate. And this is not an accommodation seminar, because that would take too long. So what I want to do is simply raise the issue, highlight again, as many of you know, the test of undue hardship is not inconvenience or inconsistency from one employee to another, or inefficiency in the operations and how quickly you can produce your product or provide your service, or moderate cost associated with the accommodation. That is not undue hardship. So when an employer is considering this, you must really sort of recognize that there's a significant imposition. B4, so bona fide occupational requirement. There may be situations where you cannot accommodate, and the examples that I would use is one of your employees is required to travel by plane or train, and those entities, whether by government decree or otherwise, are refusing to board anyone who is unvaccinated. Well, that will be difficult to accommodate. Another one that I think is going to come up far more often is a situation where a customer says, we are not allowing non-vaccinated visitors in our workspace. that may be a reason for you to say, well, I cannot accommodate you as a salesperson or as a service person or whoever it is that needs to go on to the client's location. But I would remind you that the case law is fairly developed, that an employer is not immune from an allegation of discrimination because they are carrying out what would be considered a discriminatory action of their customer or their supplier. And so it is not a simple excuse or reason to deny somebody their livelihood by simply saying, well, our customers won't allow you to be there. The other thing I want to remind everyone of is that there is a duty to cooperate in any accommodation request. So the first thing they have to do, the employee must disclose why it is that they are rejecting the vaccination or why it is that they cannot satisfy the mandatory policy that you've implemented. And of course, they're going to identify disability or creed. We'll have to see what that is, but you're going to have to deal with that. And the privacy issues regarding medical status and the reason to request the accommodation, you must recognize that that is very sensitive information, and you're going to have to maintain it, collect it, store it, etc., with the highest level of security, because that is their status is certainly a medical situation or a medical status that you need to recognize. I remind those in Ontario that there is a specific health and safety exception in the definition of accommodation in the Ontario Code. So that is going to be something that employers can rely upon. What are the forms of accommodation that may be available? Remote working, we've all been, or many of us have been experiencing that. Enhanced personal protective equipment, maybe that's enough. Enhanced social distancing measures, maybe that's enough. As Cedric mentioned in the Quebec context, testing with the disclosure of results to the employer, so frequent testing. So if one considers the Quebec approach, as Cedric described, that looks like a pretty good process to at least be aware of and to consider if you're going to implement this kind of a policy. And it ultimately ends with the removal of the employee from the workplace without pay. Again, another reminder, individualized, flexible accommodation is required. There cannot be a one-size-fits-all approach to accommodation. Next slide, please. Cedric, do you want to talk a little bit more?
Yeah, so I just want to thank you, Chris, for this opportunity. I just want to take a little time to circle back to the fundamental rights applicable in Quebec. And as we've seen in the human rights section that Chris just talked about, it will be really similar for Quebec. So as I previously mentioned, employees have the right to integrity of the person, the right to self-determination with respect to healthcare, and the right to equality. And for equality, the prohibited grounds of discrimination will be really similar in Quebec. We're talking about religion and disability, which could be interpreted to include medical condition. The thing is that a mandatory vaccination policy will infringe on those fundamental rights. But the Charter provides that it is possible to infringe on those rights in the sense that the employer will have to establish that the nature of his activities justifies to do so. And the test is the following: the employer must establish that the limit is imposed in the pursuit of a legitimate and important objective and is proportionate to that objective. And this will vary from every employer based on the nature of its activities. And Chris mentioned factors that will certainly be invoked by employers. We're talking about contact with the public, contact with the vulnerable population, previous outbreaks. And this cannot be an evaluation for all of the companies. So you cannot say, oh, my company requires mandatory vaccination. It has to be evaluated for every position, as every position within the company has a different reality, whether it's working in a warehouse or working in the offices. So another issue in Quebec, and I'll ask you to move to the next slide, is the privacy risk. So in Quebec, the Charter of Human Rights and Freedom and the Civil Code of Quebec also protect the right to privacy of every individual, which would include employees. In addition, in Quebec, we have the Act respecting the protection of personal information in the private sector, which regulates the collection, the use, and the disclosure of personal data And this category of personal data would include the medical information of the employees. So the basic question that we can ask is, can an employer require the employee to disclose the fact that he was vaccinated or not? This is a medical information that belongs to the employee. And so the first question that we must answer is, well, is the vaccination required by the nature of the activities? And as I've previously explained, it's kind of a difficult threshold to reach, but it's the test that we previously saw, that is the nature of the activities sufficient to justify the mandatory vaccination? And if yes, well, the employer can require this information to assess if the employee is fit to work in that position. If the vaccination is not required by the nature of the activities, well, we believe that it's the right to privacy that would apply, and the employer could not require the employee to give this information. This being said, the employee could decide on its own to share this information with his employer, say, I've been vaccinated on this date, and I received this vaccine, and received my second dose on this further date. So this is the employee renouncing to his right to privacy, but this, of course, has to be done with the fully obtained consent of this employee. The other thing that employees should be aware of is that if the employee refused to disclose his vaccination status, well, the employer should mention to the employee that he will consider this employee as non-vaccinated. And this could be important for two reasons. First of all, it could be important depending on the vaccination policy that will be implemented by the employer. And we'll talk about this further along the presentation, but this could include having paid leaves to go get the vaccine. So in this situation where an employee refused to disclose his status, well, the employer could consider that the employee is not vaccinated. And the other reason is if there's any governmental measures that will be related to the vaccination status. And this is not the case yet in Quebec, but I'm taking the example of the vaccinal passport, where certain activities could be restricted based on vaccination. And we don't know yet if this will be implemented, and we'll have to monitor this in the future. But if this is the case, the employer should mention that if the employee does not provide proof of vaccination, he will be considered as non-vaccinated. And I believe the law in Quebec is kind of regulated, as we have the charter, we have the civil code, but in Ontario and the other provinces, it's a bit different.
Thank you, Cedric. I can chime in on Ontario. We are, as Chris mentioned before, we are lagging behind with respect to some aspects of the law. And I think it's safe to say that privacy is one aspect. Private sector privacy legislation in Ontario, simply speaking, it doesn't generally exist. BC, Alberta, and a couple of other provinces that have established private sector privacy torts, those laws and regulations are actually more in line with what we do see in Quebec. And so I will focus a little bit on them. And I will flag from the outset that we have seen a couple of attempts, let's call them, to establish private sector privacy legislation in Ontario, and they haven't been pushed through just yet. We do believe that they will be coming. And so even for those employers that are tuning in today from Ontario, consider some of the comments that are being made with respect to Quebec, Alberta, BC. They may be relevant to your workplace. And as with all things COVID-19, you probably won't be given enough runway to make the adjustment. So BC and Alberta, the legislative framework is more in line with Quebec. If an employer is interested in implementing a vaccination policy, they need to be aware that they will be collecting personal information from their employees. And so we'll talk briefly about that. What is personal information exactly? As with Quebec, the legal definition is substantially and surprisingly broad. It's any information that can identify an individual, such as their name, home address, phone number, ID number, vaccination status. It also includes information that is identifiable, including medical information. And we'll leave the definitive legal pronouncements there. The key takeaway from these privacy statutes is that they apply to all organizations within these jurisdictions and to all personal information held by that organization, unless an organization is specifically exempted under law. So what can an employer do if they want to collect this personal information in order to implement a vaccination policy, including a vaccination incentive policy that requires an employee to prove that they've been vaccinated in order to get a vaccination incentive? The short answer is Number one, you need to be accountable for the information that is provided to you. Number two, the information needs to be proportionate to the goal that you're trying to achieve. And number three, and this probably should have been number one, you need to obtain the individual's consent before obtaining the information. Consent is the key piece here, and we do see that feeding into some of the case law that's mentioned below, and we'll talk about in a moment. But employers really do need to keep the principle of consent in mind, because it underlies all privacy legislation in Canada, including within the province of Quebec. It's based on the fundamental principles that you'll see under the federal PIPEDA. I'm not going to list off what PIPEDA stand for, but the model code under the PIPEDA is where this principle of consent comes from. It's actually built upon the older principle of consent from the common law, collection, use, disclosure, and obtaining consent before doing all three of those things. So again, why should employers in Ontario or in jurisdictions where we don't have as many statutory protections in place care about all of this? The announcement of legislation in Ontario at this point in time has been breakneck pace. We get an announcement on Thursday, the legislation takes effect, possibly later that evening. And in some cases, with respect to the paid sick days legislation, it actually came in effect with retroactive impact. And so the key takeaway here is that employers could very well be legally held responsible for this personal information under their control, and they won't be given a lot of time to make that adjustment. I'd like to talk briefly about common law and some of the case law that we see that will directly impact upon this analysis from the Ontario standpoint and for common law jurisdictions. We do have torts in Ontario law, which you've probably heard about before. We have this common law tort of intrusion upon seclusion, and that tort holds that one who intentionally intrudes physically or otherwise upon the inclusion of another or his or her private affairs or concerns is subject to liability to the other for invasion of privacy. We don't see a lot of direct relevant context here that deals with the circumstances that we are talking about during COVID-19. As Chris mentioned earlier, 15 months ago, if somebody walked up to an individual with a temperature testing gun, you'd probably be reading about it, and it would probably be quite offensive in some contexts. But now, and under this new normal, and as we push forward into a newer normal, in the third wave, fourth wave of the pandemic, the frame of reference is completely changing. And so we look to these old cases for some guiding principles, but they are of limited use, I will say. I would say the same thing applies with respect to the Supreme Court Canada's ruling in Irving. The court talked about a reasonable purpose for the collection of personal information about an employee in the context of the employment relationship and for the purpose of administration of the employment relationship. That case didn't deal with vaccination. It dealt with random drug and alcohol testing, which is certainly medical information, but the risks posed by somebody being impaired at the workplace are substantially different from the risks posed by an asymptomatic carrier of COVID-19 coming in, being completely fit to perform their duties, and possibly starting an outbreak. So again, not strictly relevant to the risks and issues that we are dealing with today. I would like to look once again to the Crescent Care decision which dealt directly with the last heading on this slide, which is the charter. It talked about bodily integrity. A couple of the grievers in the Crescent Care decision, a 2021 case from just a few weeks ago, it dealt with PCR testing, the brain tickler that pulls your brains out through your sinuses. And so the Crescent Care decision dealt with this concept of breach of bodily integrity, of an individual griever coming in and saying, I can't undergo PCR testing because I have a deviated septum and it is affecting me medically and I suffer consequences for 3-4 days. The arbitrator in that case said, granted, we take that this is affecting you personally. We take that this is a significant consequence to you. However, the risks are so great in this particular time that this particular concept, this invasion of bodily integrity is actually reasonable. We look to those new cases rather than the existing past cases that deal with these issues going forward. And we would suggest that employers do the same. If I could have you transition over to the next slide, please. Chris, privacy is part of the picture. I'm wondering maybe if we can chat about some of the other risks that arise under employment law.
Thanks, Tushar. In terms of constructive dismissal, so sort of some old law concepts, You're all generally familiar with the concept of constructive dismissal. So every employee has rights and obligations in their role. If you, as the employer, unilaterally change those rights and obligations in a significant way, you run the risk of a constructive dismissal claim. That would allow the employee to resign and sue as though they had been dismissed outright. So the issue here is typically denial of access to the workplace. That's sort of at its highest level. And so if you're not vaccinated, you can't come in. We have had many employers say to us, we won't implement a mandatory vaccine policy. We'll just ask them if they're vaccinated. And as we've talked about, there are some consequences to asking. And so if the consequence of asking is that you're denied access to the workplace, well, then it's a mandatory vaccination policy, notwithstanding that you haven't called it that. And so what we need to recognize is more focus in on what are the impositions that are being put on the employee, and what are the consequences of the failure to comply with that policy. So is it denial of access to the workplace? Is it denial of attendance on customers? So I mentioned earlier, one of your customers says, unless you are vaccinated, you cannot enter our building. So you cannot provide your service, you cannot sell your goods and services, you cannot fix our machines, whatever it may be. So what is the consequence? And then I would suggest lesser consequences, because we've all been living with this for 15 months. It is the imposition of PPE on someone, or enhanced level of PPE, a constructive dismissal. My suggestion is probably not, but as we move through the vaccination process and more people get vaccinated, assuming that we get to these magical numbers of 70% and 80%, et cetera, you're going to have less and less people who are wearing masks in the workplace. So are you then increasing the potential for a constructive dismissal claim by those who continue to wear masks because they have not gotten vaccinated? Another thing that and I think is, and we'll talk a little bit about this in the practical context, is what is the consequence in a day-to-day basis down on the ground? So attendance at meetings. If a group of people are attending a meeting and they all enter the room, but one person has to sit at the far end. If the opportunity for salespeople is to attend a trade show, but unless you're vaccinated, you cannot attend, therefore you miss out on the opportunities to make contacts, which could lead to future sales, which could lead to an increase in your compensation. What about the attendance at team functions? I mean, we're all dying to get back together and to sort of socialize with our colleagues. Well, not all of our colleagues, most of our colleagues, but if you are restricted in attending those team functions, you are disassociating people from the rest of the group and isolating them. So there are going to be gradations of imposition that one needs to consider, and how serious those are. On the flip side, and this is something that I think is going to come up more and more, is you may very well have employees who are vaccinated, who are in the workplace, who are saying, I am not going to work here so long as you are allowing people who are unvaccinated to come into the workplace. I don't agree that your social distancing and your masking and whatever other impositions it is that you've placed on these people is sufficient to keep me safe. So we're going to go back to many of the things that we were considering in the early days of the pandemic, which is so and so is not behaving the way that they should, or I know that they're not social distancing and not following the rules when they're outside of work, and I don't want to work near them. So those issues are going to come back up again, and they raise the potential for constructive dismissal claims. I think at this point, I'd like to turn it over to Cedric, because I wanted him to talk about constructive dismissal in the Quebec context. No, go back to the prior slide. Please, there you go.
Thanks, Chris. So I believe the constructive dismissal in Quebec will be similar. The rules will apply. The thing is, as we've seen in Quebec, there's fundamental rights. So those are probably the first right that will be invoked, as they're clearly provided in the charter, They're clearly provided in civil code. So this is the major risk employers have for claims. But this does not mean that if an employee feels that his working condition has been substantially modified, this employee could not also do a constructive dismissal claim. And the specificity in Quebec that I just want to bring to your attention is actually our Act Respecting Labor Standards provides that if an employee has more than 2 years of continuous service and this employee is not part of the senior management personnel, well, our Act Respecting Labor Standards provide the right to reinstatement. So this is to be kept in mind by employers. For the next slide, we'll talk about workers' compensation and no-fault compensation. So provided that you have a vaccine policy and employees get vaccinated and they have adverse reaction, what is kind of the legal framework applicable to those employees suffering adverse reactions? Well, the CNSST took an administrative position, the CNSST being the labor board in Quebec, and said that, well, adverse vaccination, if the vaccine was administered because of or in the course of the work, well, the employer will have the opportunity to benefit from workers' comp, which is the Act Respecting Industrial Accident and Occupational Disease in Quebec. This means that there will be no civil liability against the employer, but the impact of this claim will be to raise the premium of the employer. It's like an insurance. So if the insurance money is paid, well, the premium will be further affected. The other system that we have in Quebec that is kind of different from the other provinces, from my understanding, is the Vaccine Injury Compensation Program. This is a program that is a no-fault regime. This means that every individual, and this does not apply to employees, so this is not specific to employees, so any individuals that is vaccinated in Quebec and suffers adverse reaction can be compensated for the damages that he suffered. And this regime has been in place for quite some time. It's not new to COVID-19. It was previously existing. Basically, it is provided in our Public Health Act and regulations. And the Vaccine Injury Compensation Program is available for a list of vaccines. And recently, on April 21st, by Decree 592, the government included Corona vaccine in the list of the vaccine that can be compensated in the program. Basically, the individual does not have to prove the fault of the minister or the person administering the vaccine, just have to prove that he suffered damages and the damages result from the vaccine. And this individual will be compensated like if it was a car accident. So it's evaluated by the Société de l'Assurance Automobile du Québec, which is responsible for the no-fault regime of car insurance. And so they will evaluate the damages, and the person might be entitled to income replacement indemnities, bodily injury indemnities, and other indemnities related to the adverse reaction. And I'll pass it to Tashara and Chris, because I believe there's a similar process being developed in Canada right now.
Thank you so much, Cedric. Absolutely correct on that. And I can comment a little bit about, I'll start off with, sorry, if you could move to the next slide, please. Thank you so much. I'll start off about talking about negative or adverse reactions to a vaccination or a vaccine. In Ontario, we've actually got a recent change to the WSIB's policy framework with respect to COVID-19, in that if an employee, and if they suffer an adverse reaction, there may be coverage. And I'll quote directly from the policy because it is quite significant and it could significantly affect an employer's ability and risk profile with respect to establishing a mandatory vaccination policy or framework. When determining whether a reaction to a COVID-19 vaccination is work-related, that's a key piece in order for coverage to extend under the Workplace Safety and Insurance Act. The WSIB considers, one, whether the vaccination was a compulsory part, so a mandatory vaccination of your employment, And a vaccination is generally considered compulsory if the employer has a rule or policy in place, and they get into what a rule or policy is. We can skip that. The part of it is including the threat of termination, the threat of penalties or job changes if you're not vaccinated. And then number two, they'll consider whether or not the reaction is adverse. And so a serious or unexpected reaction, such as the types of events that would normally be reported to a public health unit. And so if the reaction requires medical treatment beyond first aid, requires an absence of work for more than a few days, it indicates that the reaction in its severity or duration has likely gone beyond the expected reaction from a vaccination. The jury is still out on whether this will affect premiums. We are crossing our fingers and we are hopeful here because other COVID claims that have been administered through the WSIB, they've indicated through their COVID-19 FAQs that the claims will actually not affect premiums directly. They'll be attributed to entire rate groups and schedules. And so that's a piece of good news. Now, I understand we're not strictly focusing on Ontario, that we are looking at this from other provincial aspects as well, and other workers' compensation boards located throughout Canada outside of Quebec are all lining up with the Ontario and Quebec approach to this issue. We're seeing an alignment here, and the reason for that is because workplace transmission is a significant risk in the present context. So those are great for workers' compensation or WSIB covered workplaces. And they offer a very significant benefit in that an employee is barred from bringing a statutory claim, a civil claim pursuant to a statutory bar against a civil claim under the WSIA. And so if coverage could have applied and would have applied under the WSIA, it can actually be barred from filing a civil tort claim against the employer. That's of significant help. What if you are not WSIB or WCB regulated? You operate a publishing company and everybody's working from home. There's also hope in the context of the Canadian Vaccine Injury Support Program, or what I call the VISP. So the VISP is still in its nascency. The last update that we've received from the federal government was actually dated just last week. There are calls for applications for the administration of the program. But it essentially does the same thing where other statutory frameworks and mechanisms, they drop off. And so if an employer does not have a WSIB or WCB account, or they're not required to have a WSIB or WCB account, haven't decided to opt in, this program would actually, at least notionally, step in and cover risks and liabilities related to COVID-19 vaccination and possible adverse effects. And we use the same terminology here. It's a no-fault system. It's somewhat the same as your car insurance, as Cedric had mentioned. If we can switch over to the next slide, please. We're actually going to switch gears a little bit from talking about the risks associated with a COVID-19 policy and establishing a mandatory policy at this time. And so you'll see from the last discussion that there are mixed signals coming from various provinces and regulators. Some are ahead of others. We're talking now about the inverse. We're talking about what happens and what is the risk of having no mandatory vaccination policy. Chris and I are based in Ontario, so we'll focus on home base. We have been dealing with Section 22 class orders under the HPPA, the Health Protection and Promotion Act. And what happens and why is that relevant to your analysis where you're based? What if you're in BC, Alberta? We are seeing an alignment between the different provinces with respect to workplace transmission and a focus on keeping workplaces safe. There has been increased enforcement, and the powers of the local health unit in your particular region are by and large the same. And in essence, they're the same as what your Ministry of Labor inspector can do. A workplace inspector pursuant to the local health unit can actually come in and shut you down. And that's the key piece that we will focus on here. So recently, you might have heard that in Peel, in Toronto, and in Hamilton, there has been the introduction of a class order in each public health unit by the chief medical officer of that unit, stating an intention to close workplaces where there are 5 or more cases of COVID-19 that are attributable to the workplace, that workplace transmission piece, within a given 14-day period. That's quite significant. They've expressly stated that they will utilize their powers, and they have done so. I think the current tally for just Peel alone was 16 as of yesterday, and they are really focusing on workplaces that are operating within these hot zones. Could a mandatory vaccination policy actually assist with respect to curtailing some of the risks of closures that are arising in the context of these new class orders? In your local jurisdiction, remember once again, your health unit has the same authority under emergency management legislation, under health protection legislation, to come in, assess a situation, and take every precaution reasonable in the circumstances to stop an outbreak, including shutting or partially shutting down a workplace. So that is probably one of the primary risks associated with having no mandatory vaccination policy. We don't see a legislative fine or a requirement under law, as we mentioned earlier, at least not yet. We might see it over the course of the coming weeks and months, but primarily this is the practical risk that employers will be facing on the ground. If I could have you switch to the next slide, please. I'd like to transition over to Cedric, who's actually going to be talking about the same issue in Quebec. Cedric, please take it away.
Thanks, Tushar. So once again, it will be very similar to Ontario and Quebec, but the only difference is that we do not have those strict numbers requirement. Actually, workplaces can be closed by two channels. The first one is by the Act Respecting Occupational Health and Safety. So the Dishonesty, which is Quebec Labor Board, has inspectors that go inspect every workplaces randomly, and they evaluate if the COVID-19 measures are being put in place correctly. And if they believe that there's a danger to any worker's health or safety because the Dishonesty's measures are not correctly imposed, well, they have the power to shut down the workplace until the necessary corrections are made. So this is the first channel through which a workplace can be closed. And the second channel is through the Public Health Act. And through this act, public health directors, when they're doing an epidemiological investigation and they realize that there's a specific workplace that is problematic, they can order the closing of that premises or any premises that is deemed to be problematic. And this has been the case recently. I'm talking about there's been a serious outbreak in Quebec City due to a gym. And this gym was closed by public health authorities. So those are the two channels. And it must be kept in mind that this is a risk when there's no mandatory vaccination policy. This being said, only the risk of exclusion is not sufficient to have this policy. As we previously mentioned, there's other factors to be considered in. And with this in mind, I'll pass it over to Chris and Tushar for the vaccination incentives. That is an alternative to the vaccination policy.
Thanks so much, Cedric. So as mentioned, we've got a bit of a spectrum here. I love looking at this the way that Chris did with respect to the type of workplace you have. We have a spectrum here. We've got the no vaccination incentive or no vaccination policy taking no position at all on the one side, and then we've got mandating it on the other side. And I like to think of vaccination incentives as the middle ground in present tense. And so what are we seeing play out in Ontario and other provinces, including some of the Western provinces at this point in time? We are actually seeing the introduction of paid sick days. Why is that significant for the purposes of this analysis? Well, we've got a provincial regulator, particularly in Ontario just a couple of weeks ago, coming in and saying, you know, we have recognized that individuals can take paid time away from work in order to go and get vaccinated if they're suffering adverse consequences or reactions associated with a vaccination. And they can be provided with up to 3 paid sick days and up to $200 a day. An employer may be eligible to claim reimbursement for purposes of this particular benefit. And so if you don't have a policy in place that already provided this same benefit or a version of the same benefit to employees, you can actually get reimbursement through a WSIB administered portal in the province of Ontario. And so this is a significant benefit from the provincial side that is actually in effect endorsing this sort of incentivizing employees approach to go and get vaccinated, to take the time off. We can't say enough as well. I mean, those are the strict legal side, answers for that question. Can we can we establish some sort of an incentive policy? On the soft side, on the human resources side, on the practical, dealing with employee side, employers can take a number of steps in order to facilitate this and ensure that that employees are encouraged and supported to the extent possible with respect to vaccination incentives. What does that look like? It could be providing additional time off away from work in order to book appointments. Sometimes the appointments can be hard to come by depending on which region you're in. It can be providing cash incentives. It can be providing a variety of different forms of encouragement that can support an employee on the ground. And so those aspects are critical to this analysis because there is a lot of vaccine hesitancy at this time. We've all seen reports of adverse reactions. We've seen reports from several regulators and public figures saying that taking the vaccine is like getting hit with a ton of bricks. There's been a lot of discussion about this, and so supporting employees through this period of time is of critical importance. I'd like to talk a little bit about theoretical risks under this type of a policy or a framework. Is there a possible risk of shaming if we focus on certain incentives? Let's call it T-shirts or hats that say, congratulations on being vaccinated. There could possibly be. And then we spoke earlier a little bit about the risk of collection of medical information. And so if you are collecting proof of vaccination, or your policy for purposes of an incentive requires you to collect and assess medical information about an individual's vaccination status, you really want to be thinking about those principles we talked about in the privacy piece: consent to disclosure, retention, making sure that you're safeguarding the information, and considering really at the end of the day whether or not you actually need to store and retain some of this information. As an offshoot to the vaccination incentive policy, think about whether or not you want to be encouraging employees through policies, communications, and publications that they can reference, educating them about the benefits of vaccination and really focusing on some of the key updates that have come out of the Public Health Agency of Canada, out of your local public health unit. Each of the local public health units that I've come across through my virtual travels across Canada have published quite a lot of information supporting vaccination and indicating why the COVID-19 vaccinations are safe and why they're effective. Focusing on that education rather than the sort of quick newsreel propaganda pieces that we are seeing in the news is going to be much more effective from the standpoint of educating employees, and ultimately much safer in terms of legal compliance and legal risk. You're effectively quoting a medical expert in a sense, and putting this in front of employees as an authority, indicating to them what is and isn't safe. And finally, I'll touch upon this piece as it ties into the education component. When you are pushing the boat out with respect to a vaccination incentive or a vaccination encouragement policy, there is a possibility that an employee could look at this particular type of approach as something that is generated out of self-interest from the business's standpoint, and really keeping the communications to the employees light and focusing on the positives and focusing on communal welfare and the benefits to the employee, their family, their colleagues, the collective community members that they're going to be dealing with. That really should be the focus of your educational campaign for purposes of a mandatory, or excuse me, a vaccination incentive policy. Next slide, please. I'll turn it over to Cedric once again to chat about this analysis from the Quebec standpoint.
Thanks, Tushar. So once again, the analysis for Quebec will be really similar, and I agree with Tushar that the best way to do it is to promote the vaccination, fully inform the employees. So all those comments would apply for Quebec. The only difference is the leaves of absences in Quebec legislation. I understand that in Ontario it was recently modified, but in Quebec, those leaves of absences were existing previous to COVID-19. So actually, our act respecting labor standards provide that an employee that is sick is allowed to leave without compensation for 26 weeks over a period of 12 months. We also have paid days for absences owing to sickness or family obligation. So those are 2 paid days, and it's either absences owing for sickness or family obligations, one or the other. So the 2 first days claimed for this period will be paid, and in Quebec legislation, it's really clear that it's the employer that will pay those days, and it's not in addition of its policy. So if he has a policy that already provides sick days, and the condition to have access to those 6 days are equivalent to those provided in the act, well, the employee will only be allowed to have access to the sick days provided in the employer's policies. With this in mind, this would close the topic of incentives to promote vaccination and would bring us to our last topic today, which are practical issues in the future. And I'll pass it over to Chris.
Thanks, Cedric. So we wanted to end with a discussion around things that you're going to see down on the ground. The stuff we've talked about is really, I mean, it's difficult to reconcile because we don't have a lot of outside of Quebec, a lot of legislation that's going to assist us. We don't have a lot of case law that's going to assist us. We have mixed messages in the media from the people from whom we need to gather this information. So we wanted to talk about a little bit sort of some practical issues that we're seeing, some practical issues that we think we're going to see as we go through this. So one of the early ones is dishonesty about the vaccination status. You can imagine a situation where an employee really wants to return to work because they're at home on an unpaid leave and needs the money, is otherwise motivated to return to work, is going crazy at home because of kids, pets, etc. They're dishonest about their vaccination status. So they tell you that they are vaccinated when they're really not. Some of you, of course, would think that that's a horrendous step, and I think I would be closer to that end of the spectrum. But there's not a lot of case law. First of all, there was a union case very early on in the COVID pandemic, where an employee, the employer's policy was, if you believe that you may have the virus and you have gone for a test, you cannot attend the workplace until you have the results of the test. That employee attended at the workplace notwithstanding during the period where they were waiting for the test results to come back. That was found out. The employee was terminated. The matter was grieved, and the arbitrator upheld the termination. So that is obviously a very serious situation where that employee believed they had symptoms, had reason to believe that they were infected, and yet came to work anyway. That's not necessarily the situation I'm talking about. I'm talking about a situation where the individual has no reason to believe that they are infected, but they are dishonest about it. From my perspective, what we need to do is you need to have a clear policy that if you're going to have a mandatory vaccination policy, it needs to be very clear that you cannot attend without confirmation of vaccination. If you are dishonest, you need to outline what the consequences of dishonesty are. They obviously potentially putting employees at risk, but I'm not certain that we can rely on that case that I referred to a few moments ago to justify a termination for just cause or a termination for willful misconduct in Ontario, etc. Let's flip that over and say somebody is in fact vaccinated, but really likes working from home on their couch, wearing their sweatpants and whatever else it is that they're doing in home, and doesn't want to return to the workplace, and so is lying about their vaccination status. In that situation, we've been dealing with those issues for a long time. People being dishonest about their ability to come to work. And so I think we would probably follow the same course that we followed in those cases. I don't think it would likely rise to the level of just cause on a first occasion. There may be circumstances where it might, but we deal with people who don't come to work, call in sick, whatever it may be. So I think it's probably in the same boat. Another risk that I see is two classes of employees. And what I mean by that is you've got your vaccinated group and your non-vaccinated group, and you are either consciously or unconsciously treating those people differently. Think of it in a circumstance where potentially the employer to some degree is holding a grudge against an employee for failing to be vaccinated, because now they have to put up with the accommodation issues, they have to deal with the social distancing, et cetera, at an enhanced level within their workplace, beyond the people who are unable to be vaccinated for human rights reasons or otherwise. So how could that manifest itself? Well, it could manifest itself in the wage or salary increases that the person gets. promotions that the person gets, or opportunities to advance within the workplace, opportunities that may lead to success in their job. So they are invited, vaccinated employees are invited to client meetings where non-vaccinated employees are not. Vaccinated employees can go to trade shows and unvaccinated cannot. Another example is what I mentioned earlier, sort of isolation of the employee. So you have in-person team meetings, whether they are scheduled or whether they are spontaneous. I'm expecting, as the weather improves and more people get vaccinated and the restrictions are reduced, there are going to be some spontaneous gatherings of teams. And so if you're not inviting someone because they're unvaccinated, you're potentially creating arguably a hostile work environment. You're running the risks of harassment claims because isolation is one of the bases upon which someone can argue harassment. There are public shamings potentially. So the example that Tushar used, where you are giving away hats that say "I'm vaccinated," and those people not wearing hats are being somehow mistreated or otherwise isolated in the workplace. We are headed towards some government mandated potentially public shaming. And so maybe this will be less of an issue in the workplace because the government is going to require people to behave in a different way or be treated differently sort of in public. And so it'll be less of an issue that way. Can I turn to the next slide, please? Another thing that I think will come forward is we have for 15 months, most employers, most clients have been very tolerant of the things that we used to, I think, be less tolerant of. So before the pandemic, if you were on a conference call and your cat walked across the screen or your dog barked or your kids came running in or whatever it is, I think that there was less tolerance for that. There would have been a perception in the eyes of at least some that you are not being serious about your work, that you're not engaged to the level that you should be. The last 15 months have seen a very much a relaxing of that, and TikTok may not have flourished as much as it did if we had been more or less tolerant, I guess. But I think we are going to head back towards what the standard used to be in certain cases. So I am seeing now remote working policies, but those remote working policies are more strict than what I think we've generally seen in the last 15 months. So there's going to be clear statements that, working from home is not for the purpose of providing childcare. Working at home requires you to have a designated workspace. Working at home requires you to have Wi-Fi of a certain standard so that you're not dropping off and rejoining and dropping off and your voice sounds like you're inside a tin can. There's going to be requirements that if you're going to work remotely, you need to meet these standards. I would expect too that when the pandemic is over, that employers are going to start to more carefully monitor and measure productivity. And what that may result in is monitoring software or protocols for being available throughout the regular working hours or core working hours or whatever it may be. And so what are we going to move toward, and are employees going to be on board with that? And what are we prepared to do by way of imposing sanction on employees who do not meet whatever standard it is? So those are things that I think you need to consider as you are developing your vaccination policy, and more importantly, how you're going to deal with people who are maybe unvaccinated, but also more broadly your remote working arrangements as many employers will move to a more flexible situation on a permanent basis. I want to talk a little bit about vaccine passports. And what I'm really focused on is the sort of the domestic use of passports, quote unquote, not so much the passport that's going to allow you to go to your sun destination, as it's being referred to these days, in terms of, I just want to get out of here. I want to go anywhere. I don't really care where I'm going as long as I can leave. And so what I've been reading, and so let's talk very briefly about what a passport is. Well, the first is it's not likely going to be a physical document as your travel passport is. It's likely to be some sort of electronic document, but it is likely going to be issued for the purpose of international travel and not likely to be issued for domestic use, whether that is access to workplaces, access to group gatherings like concerts and sporting events and whatnot. The momentum, I would suggest, appears to be against domestic vaccine passports. The Premier of Ontario has come out very clearly and said we will not have vaccine passports. Dr. Bonnie Henry, who everybody is familiar with, who watches any of the news in BC, is opposed as well. My understanding of her opposition is that it will further create divisions between segments of the population. Those that have been hit harder by the pandemic will find it more difficult to have vaccines and therefore vaccine passports. And so it will further isolate, further disadvantage those folks. And as we all know, in watching Dr. Henry, anything she says, I feel guilty if I say do anything that would be contrary to what Dr. Henry says, because of the way she says it and her general demeanor. But I also see that the group of ombuds people, or ombuds, usually used to be ombudsmen, now ombuds people, I think, are opposed. So in accessing government services, that group is opposed to a vaccine passport because it will limit the ability of people to access government services. And so it's not anticipated that vaccine passports are going to be issued. When you get a vaccine, you usually get some sort of electronic confirmation. But my expectation would be that you're not going to be able to require employees to produce some sort of a vaccine passport or to engage in a vaccine passport process should one be developed. Cedric talked about the requirements to demonstrate your vaccination status and the privacy issues, etc. In Ontario, we've talked about it from that perspective. I think it's important to recognize that confirmation will be something that is difficult. If you're creating an incentive, as we talked a few moments ago about creating incentives, well, in order to qualify for the incentive, you would have to disclose, you would have to prove that you engaged in the vaccination. But I'll stop there and see whether Cedric, I think Cedric was going to make a couple of comments, but obviously he and Tushar are both welcome to do so as we come near the end of our time.
Maybe just one last word, as we are on our way to a normal working arrangements in Quebec. Last week, the government announced its reopening plan. And as you know, Quebec is now divided in 4 kinds of zones. There's green zones, yellow zones, orange zones, and red zones, depending on the status of the virus in each region. And for now, teleworking for offices and administrative work is mandatory in red and orange zone. And the government announced in its plan that teleworking will now be gradually replaced by physical working in green zones, but teleworking is still recommended in yellow zones. And we do not have those decrees yet in Oregon Council, so we'll have to keep posted. But just the light at the end of the tunnel. I would like to share with you this small part of the reopening plan of the government of Quebec.
Thanks so much, Cedric. And I can actually chime in as well with a little bit of a send off as well about Ontario's recent reopen plan that was announced just last Thursday. We're seeing a very similar type of approach. We are seeing staged, or it used to be stages. Actually, they used to be colors. Now they're steps. So step 1, step 2, step 3 are very much tied to the percentage of the adult population that is going to be vaccinated, as well as the key health unit indicators. And so we're seeing the same thing happen in Ontario. And I would say across the country as well. So definitely to end off on a positive note, some light at the end of the tunnel. I'll speak briefly about some useful resources that we've got on our Gowling WLG COVID-19 Insights page. These slides will be distributed as well after this webinar concludes, so you'll be able to click on these links. We've linked one particular piece that still remains current. It was posted in December of 2020 that deals with workplace vaccination policies and specifically those vaccinator mask cases that we talked about earlier. But do stay in touch with us via the Insights section. And we see that there are a ton of questions. We're actually pretty short on time. If I might invite Elisa back in to run us through maybe one or two of them if we can, and help to sign us off this morning.
Thank you, Tushar. There is one question that's come up more than once in the Q&A, and that's, given the uncertainty with having a mandatory vaccination policy, what are your thoughts on if an employer just sits back and waits for the government to legislate mandatory vaccination? Is that a prudent approach to take?
I'll jump in first. I don't think that that's, I think you're waiting for an answer that's not going to come, other than to the degree that Cedric has stated. I do not anticipate that there are going to be government mandated mandatory vaccination policies in the workplaces. There may be in expansions, in education, in daycare, where they're already existing, at least in Ontario. But I do not anticipate that the government is going to jump in. What we are seeing, it's a political hot potato, and you can see a bit of the direction that people are going when you look at the Premier of Alberta, when you look at the Premier of Ontario, when you look at the Premier of BC. I mean, there's a different tenor to some of the things that they are saying. And so I think that you will be waiting probably forever outside of Quebec for that answer. And what we can see now is we've got government incentives. I mean, we'll all get a treat if our province gets to a certain percentage of vaccinations. So we can then have dinner outside. If we get, if more people get vaccinated, your kids can go and play soccer in the park. And so there's this sort of incentivizing that the government is doing to create momentum or continue the momentum, I suppose, for vaccinations. There doesn't appear to be any sort of willingness to impose that kind of requirement on people, because I think it's just politically unwise for the vast majority of them.
Thanks, Chris. I have one more question before we conclude, and that's dealing with return to the office. I think a lot of employers now are looking at a return to the office plan. And what are your thoughts on whether it's appropriate for employers to reach out to employees and ask them whether they might be in need of accommodation for medical reasons because they're not being vaccinated?
Maybe I can step in here, Lisa. I think that's probably a safe approach, but it could invite some legal risk in circumstances where, as Chris mentioned, there might be a hesitancy to disclose. There might be a refusal. I think that's where the key exposure point would arise. I think we should maybe take a step back first, though, and talk about, logistically speaking, something that should be in place before we even start that discussion, because the starting point for any return to work or return to office discussion, particularly where the office populace has been working from home for the course of the past 15 months, there need to be certain steps taken in order to even ask that question. Step one will be creating your workplace COVID-19 safety plan, having that ironed out, having isolation protocols, response plans, et cetera, in place. Once those are in place, we can actually provide the individual that might be raising accommodation issues with a menu of options and say, we can accommodate you in certain ways to reduce the risk and really focus on the reduction of risk in the workplace rather than the possible increased consequences to the individual.
Yeah, and I think I'll add to what Tushar was saying. I mean, we have been dealing with this as there have been openings and closings and lockdowns and reopenings, et cetera, probably at a lesser degree than we might have to here. I think there has been, going back to an earlier theme that I mentioned, a willingness on most employers to be flexible about those issues. I think as the pandemic comes to an end, crossed fingers, that we are going to see less flexibility from employers and more requirement to fall in step with whatever it is that we as an employer have decided is the right approach. I think Tushar's comments are absolutely appropriate. You have to get your own house in order before you're able to sort of apply any pressure to an employee to return. But from my perspective, I think what we need to do is there needs to be sort of group communication as opposed to identifying individuals, even though we may know that those individuals may not be able to be vaccinated or there could be issues with them. I think what we need to really be doing is publicizing the positives, the safety, the accommodation, the ability to accommodate workers, and then let people self-identify as opposed to going out and searching for people who we think might require that accommodation.
Thank you, Chris. So we are over time, and I think we have so many questions. Unfortunately, we won't be able to get to all of them, but if you want to reach out to Chris, Cedric, or Tushar, please feel free to do so. That was extremely informative. Thank you so much. And as I said, this is part of our webinar series. Our next webinar will be held June 24th. That will be on return to office planning, which we touched on a bit today. So if you are interested, that invitation will be sent out very shortly. So we hope you have a wonderful day, and thank you for joining us.
Thanks, folks.